So the general advice that I'd have for you is, subject to other exceptions that I kind of lay out, try to follow the flow of events and transactions. Analyze the claims as they arise throughout the fact pattern. Now, of course, you're not just typing right after you read. You're going through several rounds of reading without writing out your actual answer, but kind of sketching out notes and whatnot. But as you do that, what you want to do is still plan, generally speaking, in the order that things happen in the hypo. And more specifically, the alternate. So this may sound really commonsensical, but with other students in the past, they've tended to try to organize in all sorts of other ways. Like, for instance, by party, alphabetically, every tort committed by this person, every murder, every crime committed by that person, or they'll do it like by claim. These are all of the felony murders I found. These are all of the burglaries that I found. And so I'm just going to, like, using a really basic framework, I'm going to show you what the difference is and why that can be jarring for the professor. So here's an example of torts. This is let's say this is a whole hypo. A kicks B, B shoots at and misses C, C kicks B, and A shoots at and misses both B and C. Okay. If you do this by character or party, what you end up in, people have done this, your exam will end up looking like this. Okay, I'm going to start with A, and A committed battery against B in kind of kicking B. Let me switch to, I don't know what happened. I'm going to use the pen. So A kicks B is this claim. A commits assault against B and C, which is this claim. B commits assault versus C by shooting it and missing, and C kicks B, becomes this battery. So the wires get crossed here in a couple of places. The professors may be expecting sorry, I want the laser pointer. The professor's expecting, okay, A kicks B, okay, A kicks B, B shoots at misses C, and why am I here with A has committed assault against B and C? And so this could, in a different world where there are plenty of reasonable and logical ways to pursue things, this has its own logic, A, B, C. The problem is it puts distance between your logic and the way that your professors organize things. So unless your professor specifically said, tell me all the claims against A, and tell me all the claims against B, tell me all the claims against C, unless your professor, and I think I've never heard of a professor do this, specifically asks you to organize your exam like that, you could lose points because the professor isn't following you. And what you want to avoid is making your professor do work in figuring out how you followed his fact pattern. So that's why you want to avoid this. Okay. If you do it by claim, you end up, and again, I've had students do this as well, by kind of category of claim, you end up with batteries. So A kicks B ends up here. All the batteries, that's not a battery, that's an assault. So you go C kicks B. And you have the same problem. Like, you have wires getting crossed and the professor wondering, like, why did this person, that's not the order in which things are, and it makes it harder for the professor to grade your exam. By contrast, the pen kind of shows the simplicity of this because A kicks B, oh, looky here, A's battery versus B, B shoots it, misses C, oh, that's where I expected to see it, and it's straight across. There's no kind of crossing. here. It's just straight arrows. And I made a horrible blur out of my little thing here. So go by the order of the flow unless there's a compelling logical reason not to. And address threshold questions first. The way I define those are issues, any issue that can affect the outcome of other issues that follow or can act as like a divergence point for different issues or claims. You can only kind of identify these threshold issues that are buried farther down in the facts if you're actually planning out your answer carefully, which means that you're not reading and typing immediately, but you're reading and then kind of going over um, and deciding very deliberately how you want to answer the question. But by subject, there are more kind of specific things going on here. Maybe I'll pause there. Any questions on that? Go to the chat, or people can digitally raise their hands, apparently. Nothing on that? All right. So here's what I have that are specific. I've already had a video on this, and this also applies to tort law. With CRIM and torts, you tend to end up with kind of high transaction volume, lots of mayhem, people getting stoned and going on joy rides with friends and shooting at people, and murder and rape and robbery and stuff like this. One of the few organizational principles is that you want to start with conspiracy first. Almost many kind of high transaction CRIM hypos tends to have conspiracy. And the reason that you want to start with conspiracy is that it's a threshold issue for accessorial liability throughout the flow of events. So that when somebody does something, X shoots Y, and X was in a conspiracy with Z, and you have the kind of conspiracy where they're each liable for the other's actions in the course of that, any crimes committed pursuant to that conspiracy. When X shoots Y, you can then in the next sentence say Z is also liable for X's murder of Y because of the conspiracy that they're part of. It becomes hell to try to identify all of those things for which someone's been accessorially liable if you don't do it on the spot for that issue that raises accessorial liability issues for other members of the conspiracy. I hope that makes sense. I feel like I just said conspiracy and accessorial like 10 times. All right. So that's CRIM. That's one of the basic things. Look for conspiracy. Civ Pro, you try to go by order of the flow, but there are different kinds of Civ Pro questions. I think that order of the flow generally means following the order of Civ Pro things that happen depending on what kind of Civ Pro exam it is before the actual events themselves. So if you're basically, I'm talking about the flow of litigation, that you can follow the issues if it's that kind of Civ Pro exam where you're going through procedure and filing deadlines and initiating federal litigation. You kind of follow notice and service of process, and then the complaint and other things that happen like that. And that ordering may or may not be more important than any substance of a claim that happens, depending on whether or not they're mixed. I think you also want to try to address threshold issues. Again, it depends on what kind of mix of things you get for Civ Pro, but in if you're looking at a bunch of different types of, if you cover different types of motions, you want to look at things like jurisdiction that can cut off the rest of the case immediately. It doesn't mean that you don't cover those other things. That's a super important point. You try to cover um, all the different possibilities, but if there are issues that will kind of end the case faster, um, it behooves you to kind of address those first. Let me see. I think I've got a comment here. Can I read this? The person just, all right. Larry, I'm having issues on venue, service, and notice on Civ Pro. Can we talk about those at the end? And I mean, if any specific questions that you have that I can answer on the spot. If I can't answer them on the spot, I can try to get back to you on them. But let me get through these other kind of exam organization tips, and then we can maybe jump into some substance. Okay. For some of the mentor students, I've been looking at contracts problems, and I kind of feel that this is the better way to organize contracts exams. There's another way to do this, but you may want, I mean, usually you don't have a huge flow of like 10 contracts in a hypo. You've normally got a couple of contracts or obligations pointing in different directions. So I think it's most helpful if you start with the different formations of different contracts, quasi-contracts, promissory estoppel, other kinds of obligations, to identify all of those. To then try to identify the different breaches and then go to the damages. I think there's a different way you could organize this, which is by each obligation that you find the contract and you do the breach and damages for that. You find another promissory estoppel in the other direction, you do that, and you kind of assess the damages in that context. But I think, and I feel less strongly about this, I think this is more of a rule of thumb than something that you need to rigidly adhere to. And I believe that you need to rigidly adhere to the rule that you've got to do conspiracy first in CRIM. I feel less strongly about this, but I think in the exams that I've seen, more of you would have had an easier time organizing your problem if you'd followed this. So, I mean, I have some subpoints on this. Formation, you try and identify all the contracts and obligations. The breaches, breaches interact with each other because of material breach. So you kind of want to identify the breaches first and kind of group them together because, and chronologically, because how they happen and why they happen will affect whether or not parties who are accused of breach then have material breach as a kind of defense. And it's a lot easier to see that if you've taken time separately to look out for all of the breaches. That does make it tricky to put damages here, but in some sense, if you're talking about different breaches, but you need to know what all the different breach combinations and possibilities are before you can say something about damages. And you want to analyze not just the damages of the outcomes that are likely, but of all the outcomes that are colorable. You want to try and trace all of the different possibilities unless they're totally ridiculous. So if some possibility is colorable, even though it's unlikely that someone would prevail on breach, but they have some argument there, still try to analyze damages for that. The other way, and this is what I was mentioning, that you might end up organizing your problem, if it makes sense within the context of one, is to take transaction or obligation one, an actual contract, or quasi-contract, other kind of obligation. You do formation, breach, and damages for that. Then you move on to the next one, formation, breach, and damages. But I think that this format tends to, is more likely to prevail because normally you're just talking about two parties or one overall transaction with different obligations pointing in different ways. So you kind of want to follow this as opposed to this approach. On property, I think you can end up It depends on what kind of property questions you have, but if they're mixing ownership and like conveyance, uh, uh, you may want to try to figure out different um, conveyance in the sense of wills. You may want to try and settle ownership disputes first as a threshold issue, or the kind of estate that has been acquired by someone before they end up conveying it. That's so general as to possibly be useless, but that's what I have for you on that.